everyone. Welcome to the California Legal and HR Updates for Restaurants. This is being sponsored by the Restaurant Success Center, and we're so glad that you're here today. My name is Celeste Young Ramos. I am a restaurant advisor located here in Los Angeles, California. I'm also certified in California Human Resources. And I have been a multi-level restaurant operator for most of my career. And we wanted to share with you some of the updates that's going to impact you and your operation of your business this year. So today I'm going to talk about the new California minimum wage changes and how they're going to impact your business. We'll talk about exempt employees' salaries. We'll talk about Wage Theft Act, the new California sick leave law, and the older bereavement leave. And then finally, we'll end off with changes to the California food handlers cards. So as of January 1st, the California state minimum wage is now $16 per hour, regardless of your company size. A couple years ago, we did it if you were 25 or lower, it was a certain rate, and then it was 26 or above, the rate was a little bit more. But now, because we've reached a high level of inflation, we have this trigger that increases the minimum wage and does it universally for everyone. So no matter what company size, $16 is it, unless you are in one of the 19 cities or counties where they have a higher minimum wage. So most of my clients are here in the city of Los Angeles. We do our minimum wages in July instead of January, and some of those other counties throughout the state and cities do the same. So usually they'll post that information about what that increase will be in February, which is kind of sad because we've already done our business projections for the year, right? And so it's a little bit tricky trying to estimate what the government's going to do. But since they went up 50 cents here with the state minimum wage, I'm assuming we'll see at least a 50-cent increase on our city minimum wage as well. Right now, the city of Los Angeles minimum wage is $16.78 per hour. Now, whenever minimum wage goes up, that also is going to impact what you pay your exempt salaried employees. So the requirement is they're supposed to receive 2 times the state minimum wage, or the $32 an hour. If our minimum wage is 16, it's going to be $32 per hour. You then multiply that out by 40 hours in a week and by 52 weeks in a year, and it comes out to $66,560. Now, just because you're paying them that amount doesn't mean that they can be totally exempt. And when I talk about exempt, I mean that they don't have to be held accountable to the 10-minute breaks, the overtime, and the 30-minute meal periods. That's why a lot of business owners want to take advantage of that exemption. But the key thing here is they have to meet 3 other conditions. First, they have to be somebody that's actually has control of the business. So they're able to make hiring and firing decisions. Okay. They also need to supervise at least 2 employees. And they have to make sure that they do 51% or more of their daily activities in managerial duties. And sometimes that can be hard, particularly in fast food, when the manager might be taking orders and seating and giving people breaks and all those kind of things. So many fast food companies have gone away from doing salaried exempt. And if you find that you're not meeting these qualifications for counting the dollar amount, you could have your people be salaried, but you would need to make sure that they follow the break and overtime rules. A misclassification of one of your employees here from being exempt salaried and being a regular employee is a $5,000 to $15,000 penalty per violation. So if you're in doubt, please check with Human Resources or your legal advisor. Now, another thing that's going to be affecting minimum wage in our state, last year we were really paying a close eye on the Fast Food Recovery Act, AB 257, and it was slated to even be on the ballot, but there was some mix-up, I guess, with signatures. And, you know, it was something that for sure franchise situations we're not looking forward to. It was going to cost them, where the franchisor would be responsible for all the things that the franchisees did. In addition, it was going to raise the minimum wage to $22 an hour, and it was going to also put a 10-person council that was going to be responsible for all the labor law decisions for fast food. And there were quite a few that they were going to have control over. But Governor Newsom negotiated with a couple of the labor unions that were really promoting that, and they came to an agreement that they would amend it to have a fast food minimum wage at $20 an hour. This will go in effect on April 1st of 2024. And it applies to chains with 60 or more locations across the nation. So more of those big gun type chains out there. There will be a council still that's going to be in place, but now they're only going to be able to control the wage, and they'll be able to set the wage annually through the year 2029, and it will either raise by whichever is lower, 3.5%, or the annual change in the consumer price index. So lately, this consumer price index has been much more than that, so we've seen a larger than a 3.5 increase. But whichever is the lower will be the one that will apply to that. Now, whenever we have minimum wage goes up, that puts a lot of pressure on us as operators, particularly in the fact that we have to raise the minimum wage to our lower earners, but also we see what we call wage compression, where maybe the servers are now moved up to $16 an hour, and then the cooks want to see that they're getting raised more as well because they feel they're getting too close. I know from being an operator of multi-level that usually my cooks wanted to see a $3 minimum difference between them and the servers. So, I would expect that the cooks are going to be up closer to 19, going to 20. Some of them in, higher level businesses, with higher menu costs to the clients will already be well above that. But the minimum wage for what they say is the cost of living wage in the state of California for a single person is $21. So we're still, even though minimum wage has moved up, we're still well below that level. And so we're going to continue to see minimum wages over the years continue to rise as the state legislation wants to bring more living wages to workers out there. Now, I was doing a lot of reading on this because I wanted to know, like, if that's going up, how much do we need to raise the prices of our menus? Every time a minimum wage goes up, we would take a price increase. And so I know that the two of the biggest guns out there, particularly with the fast food, McDonald's hasn't released yet what they're going to raise their minimum wage, or their not minimum wage, their cost to the customer. But Chipotle has said they're going to raise it to a mid to high single digit. So that means they're going to move it up probably between 5 and 9% increase on prices to the customers. So this economics professor at UC Berkeley, Michael Reich, he said that when wages rise 10%, then the cost of the restaurant menus that go out to the consumers usually raise about 2 to 3%. And it's done on a one-time basis, like when they do the minimum wage. So if you're going to be in fast food, you need to, already have taken a minimum wage increase here if you're in the state. But if you are going to be part of that 60 unit or larger chain, you'll need to take another big hike here in April. And, fortunately, our customers will be educated and expect, as they hear about it on the news, that these wage increases have gone up. They'll expect that the cost to them is going to go up as well. Now, talking about all this money, I did want to talk about wage theft. So, according to a study last year, 85% of California fast food workers that were surveyed claimed to be victims of wage theft. 59% reported denial of sick pay. 27% reported violations in overtime and minimum wage. And 53% reported having their rest breaks withheld or interrupted without proper compensation. So as we know, if an employee has their 10-minute break or their 30-minute meal period interrupted, they're supposed to get a 1 full hour of pay at the regular rate of pay, not minimum wage, at the regular rate, whatever that may be, to compensate for that 30-minute loss. And that's not happening in many places. So we really need to pay closer attention to that, because last year they actually passed a law called AB 1003, which is a Wage Theft Act. And it is now found that if an employer intentionally has a theft of wages of an amount of over $950 for one employee or $2,300 for a group of employees, that is now grand theft in the California Penal Code, and will be a felony instead of a misdemeanor. So that's putting a lot more criminal liability on business owners if they're doing things that aren't proper. So typical ways that we might see this theft occur in the restaurants is not meeting the minimum wage, or not paying them overtime when they should have been paid overtime, not giving them that premium meal or rest period penalty. And also sometimes when I talk to restaurant owners, some people are actually withholding tips or charging their employees for the credit card processing fees. And that can be a theft as well. Or if you charge them for branded uniforms, and it brings their wage, if employers are providing branded uniforms, they're supposed to pay for it. So there's a lot of ways that this theft can come into play. And as our employees become more knowledgeable, they are learning these laws and they're taking advantage of it. So you really need to be very careful. And all of these things here, not only for theft, put you at risk for a PAGA lawsuit, a Private Attorney General's Act, which has really been plaguing the food industry since probably, I think, around 2013 when it went in place. But prior to PAGA lawsuits, the big lawsuits for attorneys to go after were wrongful termination or sexual harassment. But now with PAGA lawsuits, that has become the preferred litigation type lawsuit, because it's based on grouping all the employees together over a 3-year period, and every pay period that something is incorrect, giving a fine. So for instance, if I fail to pay them 1 hour for that missed meal break, I will get a fine the first time I do it of $100 for that pay period. If they find that I've done it a subsequent time, it's going to be $200. And there'll probably also be a fine for not paying it on time and having it not correct on the paycheck. So sometimes when we're trying to save like $16, we may be racking up a fine of $300 or more. And that's why the average PAGA lawsuit in California is $1 million. So you can see how quickly it can add up, particularly if they're going back and looking at all of your labor laws for the past 3 years. Now, there is a form we're supposed to be giving out to all employees within 7 days of hiring or within 7 days of their wage changing, your workers' compensation carrier changing, or the sick leave policy changing. And that's called the Notice to California Employee. You can Google this on the web. Just put in Notice to California Employee and you can get this same sample copy here that I got from the Department of Labor. Okay, and this is just an abbreviated section. I wanted you to kind of see what it looks like so that you say, hey, that doesn't look familiar. If it doesn't look familiar, you need to get it. What it has on here is going to be all your contact information, and it'll also have the sick leave policy. The new one that you'll get online will have the new California one that went in place here on January 21st, which I'll go through in just a moment. But it'll also have who your workers' compensation carrier is in case, they want to file a complaint or an injury and you refuse to do it. So whenever I go to do audits of restaurants and businesses out there, they hire my company to come in and look at all their labor laws to try to prevent some of these huge fines for PAGA lawsuits. And when I ask people about sick leave, the employees will give me this look like, what are you talking about? Then I know they've never received this notice because it spells it out very clearly here. So this is the state's attempt to make sure that employers cannot cheat the employees out of legislated wages. Now, another law that changed this year is the California sick leave law. Prior to January 2024, sick leave was 3 days or 24 hours, whichever is greater. So for instance, a lot of these laws are done on 8-hour increments. So like they either got 3 days, which were 8 hours, or if you have a part-time employee and they only work 4 days, that might mean they get 6 days of sick leave because they only average 4 hours over a 6-month period. So it has now changed. Sick leave is moved up to 5 days of sick leave or 40 hours. So that's 5 8-hour days. So, and that's within a 12-month period. So there's 2 ways that you can do the sick leave, just like we did before. You can either front load it, either at the first of the year, or some companies do it at a person's anniversary date, and you would front load 40 hours of sick leave into their account. Now, if you are doing it by the anniversary date, and that's in the middle of the year, maybe they started in May in 2023, you're going to have to add that difference of the 16 hours. You have to add that 16 hours into the loading of their sick leave. And sick leave is required to be printed on the paycheck. So there should be a spot where people see how much they've used and how much they have accrued. If you don't have that on there, PAGA violation for every employee that hasn't had that on their paycheck for the last 3 years, for every single pay period. So that can really add up. So you'll also need to have on there a line item, like where you have regular pay, overtime pay. You need to have a line for sick leave pay, where those hours will be listed there. You don't want to group it into your regular pay. You might also, if you need to pay someone that 10-minute break or that 30-minute meal period they missed, you may need to have a line on there for break premium, so that it's designated there so that people can look at it and see how they were paid out. Now, so we talked about front loading. The other way is to continue with the accrual method where they get 1 hour of sick leave for every 30 hours they work. You can continue with that same strategy as long as the accrual is regular and results in the accrual of no less than 24 hours or 3 days of sick leave by their 120th day. or no less than 40 hours or 5 days of sick leave by their 20th day of employment. So once again, the people have to work with you at least 30 days to get this. They can't take their sick leave until 90 days. It's not payable out when you terminate them. It's just a benefit they've lost. If they do return back to work for you within 1 year, you have to reinstate their unused sick leave. And I highly recommend having them separate from time off, like personal time off policies. Because if you have it under a personal time off policy and you terminate them, you have to pay them out all of the hours that they've accrued. Whereas you don't have to do that with sick leave. So I would have like vacation pay as one and sick leave as a separate category altogether, because you may not have to pay that out when they're terminated. Now, with the capping of the sick leave, when you're doing the bucket or front loading method where you put all of those hours in annually, you'll just reload it at the end of the year. If you're using an accrual method, you can cap, it's a state capped at 80 hours or 10 days, but you can put in your employee policy that you could limit them to using 40 hours a year or 5 days per 12-month period. And that might be better for you so that you can control how much can be used at one time. So also with this cap, if they hit 80 hours, it just stops accruing anymore after that point. Okay? So under the old law, they could only accrue 48 hours, was their annual cap, and you could only set it for 24 hours of use. So now this is doubled with this new law. All right. Another law that came out, it was actually previously came out as Assembly Bill 2188, was marijuana testing. This year, they made some additional changes because marijuana is allowed for recreational use here in California. So they're changing the requirements for what type of test can be given to test for drugs. So for instance, for employment or firing people, you can't use hair or urine tests, which hold the marijuana in the system a lot longer. So there's going to be some different types of tests that will be available now for that. Also, you cannot ask applicants about prior cannabis use except if the worker is in the construction industry or they're applying for a position that requires federal background checks. Okay, so you can have a policy in your company not to allow marijuana in the workplace. As a possession or use, that's totally fine. You can have a policy where people are tested for marijuana after work injuries, for instance. That's completely legal. But you need to make sure that you have a policy in place. Now, last year they passed an bereavement leave. That's in case someone dies in your family. That actually went in place last year in January if you had 5 or more employees. This year they made an amendment to it, adding a pregnancy loss to it. So how the bereavement leave works is you have 5 days given to employees who have a qualifying member pass away, such as a spouse, a child, a parent, a sibling, a grandparent, grandchild, a domestic partner, or partner-in-law. And just like with the sick leave, they're allowing also an individual. So like a person, like maybe you have a roommate, you two roommates in an apartment, you can designate one individual per year to be on the list as well, as long as you have that in your company policy. And the employee has to be employed for 30 days. They have to use the leave within 90 days. And there's no limit to these leaves per year, but you can check for proof of the incident. So, if you've got an employee that's kind of out there and says their father died twice in 1 year, you can always ask for proof like a death certificate or funeral announcement or something like that if you want to clarify that they're not taking inappropriate leave. Now, this leave is not paid. It's unpaid time. And lastly, California food handlers cards. There's been a change here with SB 476. This is new news that some of you are not going to be happy about it. So as of January, employers are now required to pay for training courses and also compensate the employee for the hours worked during the time they're taking the class and the exam, and any necessary expenditures or losses associated with obtaining the food handler card. I'm not sure what that means. If any of you know what that means, you can put it down below in the comments. I can't think of any other costs that they may inquire taking the class. So particularly since this class is something where if they don't pass, they keep taking it over and over until they pass. And usually with most companies, that's free. So, so this is going to be something that you're going to now have to plan for. You may also have to plan, like, which company am I going to use to do this type of training? There are some requirements in the law that you can't have the cost be more than $15. Also, the course and exam must be able to be done within 2.5 hours. So right there, if you may want to go toward a class that does all the required information in less time. I know here at Restaurant Success Center, our class is only 1.5 hours. And so you'll save at least an hour of minimum wage by using our company. It is going to require a test of 40 food safety questions, and they have to pass with a score of 70%. At that point, they'll be given a certificate, which they should show to you. Now, that certificate does belong to them, and if they do leave you, they do have the right to have their certificate. So it's not something that you can withhold from them. Now, there are some carve-outs there for different food companies that they say you still have to have the California food handlers card, but you don't have to pay for it. And you don't have to pay for the time of them taking the class. And that's if you're with a certified farmer's market, you're a commissary, a grocery store and convenience store, you're a licensed healthcare facility, you're a mobile support unit. This would be like the Red Cross taking food, to feed the homeless or something in a national disaster or something like that. Public and private school cafeterias, restricted food service facilities such as like prisons and things, retail stores if most of their sales are from pharmacy, or certain venues where they have snack bars and the majority of their tickets, their sales are through tickets. So for instance, a bowling alley where they have a snack bar, they're going to have to pay for their training because they're not charging admission tickets. And then they put, and if you have an in-house training program. Now, I read this 5 times and it was so vague about what they meant if you had your own in-house training program and what exactly has to be trained. It did list some legislation that, that they put out when they first mentioned California food handlers. So we'll get more information on this, and as we hear more, we'll definitely keep you informed. And if you're ever in question of whether your employees need a California food handler's card, please ask your health inspector. And we want to finish off by talking about there's a new version of the Form I-9 for immigration available. The new expiration date is 7/31/2026. And this one has 4 pages in total. The first page has been combined to have the employee section and the manager ID verification. The second page is a list of acceptable documents. The third page is the translator affidavit. This is what you'll use if you or someone else helps that person to fill out their I-9, you'll have to complete that page. And then the fourth page is for re-verifications and rehiring. So if someone has a name change, you need to update their work authorization, or they come back to work with you within a year, you can complete that form and have it all good to go. I do see when I do audits that sometimes managers are signing that re-verification section, even when they're not re-verifying anyone, and they don't need to be signing that. They only need to be signing in page 1. So if you have any new hires from this point on, you should be using this new form. Will want to also update your labor law posters because the minimum wage change. And if you've had a city minimum wage change, you'll want to update. Usually they have a separate poster, like the city of LA and the unincorporated areas of LA County will have an addendum poster that you're required to post. So make sure you update those as well, particularly if the minimum wage goes up in those areas. So that's it for the labor law changes. We are going to have another free webinar if you liked this one coming up on January 9th from 2 to 3:30. It's called The 4 Steps to Successful Restaurant Goal Setting. I'll be going over determining what your gap is from where you want to be, SMART goals, mind mapping, and actually setting action steps that will lead you to success. I will be listing down below in the comments the dates of these upcoming webinars, and we will have another live webinar on this labor laws. I'll put that in the comments down below too if you'd like to attend that webinar and ask some direct questions. So here are our contact information. We're the Restaurant Success Center. We're based here in Los Angeles. We serve restaurants throughout the state of California and beyond, but California is our specialty. If you need help with improving your operations, getting compliant with human resources, or improving your training programs, then we're the place to come. We provide the same type of service and quality that you'd receive at a national brand for the small business restaurant operator. So thank you, everyone. Happy New Year. I hope to see you or speak to you in the near future. Have a sparkling day.